Hello everyone and welcome to Uncivil Law. For tonight's live stream content, we are covering Kyle Rittenhouse trial, day number 13, entitled, Please Kyle Hire a Better Lawyer. The defense lawyers in this case are not good. They are bad. They continue to make obvious, notable mistakes that are unforgivable. The case for ineffective assistance of counsel on appeal continues to grow with every passing moment, and I can't believe that the defense lawyers are really this bad. The prosecutors have made mistakes too. They made one today, at least in my opinion, but they've been nowhere near as bad as the defense lawyers in terms of making mistakes in terms of service of their client. They have consistently failed to make critical objections. They have consistently failed to advocate for their client zealously. And on more than few occasions, they have completely failed to take victory just being handed to them. It's being handed to them, and they still can't manage to do it. So this is very, very annoying. I know any number of people in law school who do moot court and mock trial who could do a better job than this, no problem. This is unbelievably frustrating. I don't know where we found these lawyers, Richards in particular, but even Sharifi to some degree. I don't know where we found these lawyers and why they continue to be hired. It is amazing. So first, apologies for the late hour. I was out on a date with my bae, and we had a wonderful time at a distillery in Waco, and I don't want to deprive you guys of some law. So I'm gonna give you some law tonight, and yeah, so let's do this thing. All right. So for tonight's video, I'm going to look at some moments of the video, all right, that happened today during the arguments. And so let's just start with this. And we're going to go to this moment. So the jury is not present for any of this, by the way. This is just motion practice while the jury is out. At this point in the hearing, the judge has received a request to receive for the jury to watch some video. And so there's a debate about what video they might be allowed to see or might not be allowed to see. There's a debate about where, and there's a debate about how many times they might be allowed to watch the video, because there's some case law dealing with undue emphasis of evidence. But that's not really important right now. What we are going to be talking, so this whole discussion is taking part of that, right? So they're discussing the jury questions, which was at this point, can we view some videos? Right, they're discussing this, and then the judge brings up a different subject. So let's do that.
I have had the chance during the break to read the defendant's motion for dismissal.
Yes.
And there are allegations made there about the material that was provided to them.
Yes.
Certainly if I follow through on what you want, I think I warned the other day because I was queasy, very queasy about this particular exhibit of from the drone. And we exchanged a lot of emails over the weekend about it. And I think I warned you the other day that you're putting an awful lot of emphasis on this. And if it turns out that it's not technologically sound, I referred to it as the situation as a house of cards. This is just more weight on that. If I now allow them to review it without restriction as to the number of times,
Judge,
you're comfortable with that?
Okay, so here is what's happening at this point of the video. So I want to talk about what the judge just said, okay? So first thing he says is, I just got a chance to read the motion to dismiss. At this point, he's referring to the written motion that was filed the previous evening, I believe, which is a motion to dismiss with prejudice. That is a motion that, if granted, would cause this case to go away forever, right? That's what with prejudice means. All right, it means that any future filing is prejudged. That's what prejudice is, right? So he says, okay, I've read this request to dismiss with prejudice. Now he's talking about this video. He's talking about this low quality video that's been enhanced and manipulated, and with the experts and all the rest of it, and no one knows what's going on. And what does he say? He says it makes me queasy. It makes me concerned. He says this evidence is suspect, and if they're going to start playing this back over and over again, then that raises concerns in my mind because of this low quality video. Right? This video, which is already part of the record. So the judge has just said, okay, I'm getting queasy. I'm concerned about this. I'm not 100% sure, basically implicitly saying, I'm not 100% sure I would let in this evidence now. Right? That's what he's implicitly saying. I'm not sure I should have let that evidence in. Right? Now, the prosecution starts talking. Now, if I were the defense lawyer, I would start talking because I'd be like, Your Honor, you said it yourself. You just said it, right? But the defense yields to the prosecutor. They don't get up. They don't emphasize the point. And they move on, right? They completely move on in the exchange. So it's a wasted opportunity. The judge says, I'm feeling queasy. I'm feeling concerned. I'm not so sure about this video. Not sure about the quality. They're complaining the quality of the video they got isn't the same quality as the one you got. I'm concerned about the video that's been presented into evidence. Concerned about the jury's reliance on it. Seems like a lot of weight on this questionable evidence. This is all good things if you're the defense. You should be harping on this, right? You should be jumping up and harping on this. But no, the prosecution goes first and the defense just keeps letting them talk until they basically forget the whole issue. And what were we talking about again? Oh yeah, let's just do the video thing, right? So this is a missed opportunity, but this isn't really the one that really frustrates me the most. This is just the first moment of three. This is the first moment of three where the defense kind of drops the ball. All right, now let's go to 4 hours, 52 minutes, or 4 hours, 4 hours, 52 minutes. Where's the second time they drop the ball, okay?
Going to open air closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video. I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this, and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
All right.
Okay. Mistake number 2. This is a big mistake. This is a big mistake. The defense earlier filed a written motion for dismissal with prejudice, right? We want dismissal with prejudice. We don't want this case coming back. All right. So an hour and 20 minutes later, the defense says, you know what? How about dismissal without prejudice? What? Why would you do this? Why would you do this? They say, we understand the state can retry. We understand they will retry. But we think about, because of fundamental fairness and making sure everything's open, we should have had access to the full high quality video. Okay. I mean, yes. But that was part of the reason you asked to move to dismiss with prejudice. Remember? In your written filings? And now you're moving to ask to dismiss without prejudice, which would allow them to bring the case back. Would allow them to try the case again. Why are you doing this? Why are you doing this? It doesn't make any sense. Now, the prosecution, to my very deep amazement, fights this. I don't know why. I honest to God can't figure it out. Because I would think a motion to dismiss without prejudice would make the prosecution super duper happy. Super happy. Because, it's not going great. They have the same grapevine that we all do. They know that they're losing their case, at least on the top counts. They know that that this is not going great. Why the defense wouldn't do this unless they think they're losing? But how can they think that they're losing? How can they think the jury's ready to convict on these top counts? How can they think that? That isn't sort of the scuttlebutt. We're looking much more like a hung jury to me. Why the prosecution doesn't agree to this and just hit the redo button? Because it would moot every issue, right? It would moot all the things. It moots all the things. Ineffective assistance of counsel, Brady issues, failure to disclose, constitutional violations, right? It moots all the things, all the issues. We don't have to worry about the fact that we didn't disclose that material. We don't have to worry about Brady. We don't have to worry about the fact that in open court we mentioned the fact that Kyle didn't speak, because we're definitely not going to mention that again in a new trial. We don't have to worry about the fact that we have these problems with our experts who don't know shit, who can't testify about how certain things are done in terms of images being manipulated or not. We don't have to do that. So it moots all the things. Why wouldn't you take this? Learn from your mistakes. Maybe don't make the defense's case for them during much of your questioning on direct. That would be good if you're the prosecutor. Just don't hand them your case. Half of what's working for the defense is the prosecutor just constantly handing them their case. Certainly not due to the defense. So why the prosecution fights this is beyond me. But even more frustrating is why the defense would ask for this. Because they've got lots of issues on the record. They've already asked for a motion to dismiss with prejudice. And they're like, how about instead of with prejudice, how about without prejudice? Why would they do that? Why would they do that? I don't know. That's bizarre. But as bizarre as that is, as bad a misstep as that is, and it's pretty bad, I think the third one might take the cake. It's close between 2 and 3, though. So which one is worse? Might be a bit in the eye of the beholder. But number 3, also bad. So let's skip forward another, this is only 10 minutes later. This is at 5:03:45. And let's listen to this little exchange here. Okay? Pay attention.
We object. Pardon me? How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive because, but anyway.
It's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know there was another version. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect to these things. My feeling is I had my qualms And I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis, but that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. I forewarned you. You know, you've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly.
Okay. All right. This might be the most frustrating moment because of what isn't said after this. Right? What's really frustrating is what didn't happen after this. Now, sometimes you don't know the right words to say. It happens to the best of us. It happens to the best lawyers. You're in court. You don't know the right words to say. You stumble over something. You don't quite have it. You know, we do our best to think off the top of our heads, but every once in a while, or more than that, depending, you know, you just can't come up with it. You just can't get it. You know, it happens to the best of us. But what is always better than your own words for either side, what is always better than your own words are either your opponent's words or the judge's words. Right? Because if it comes out of your opponent's mouth, it's a concession. If it comes out of the judge's mouth, it's already what they want to do. They're telling you what they want to do. Right? So if you're a lawyer and you don't know what words to say, one of the questions you can be asking yourself is, hey, is there anything my opponent said or anything the judge has said that I can use now? Can I use their words, accept their premise, and from their premise, argue my position? Can I do that? All right. Now, in the first video clip we saw at 3:34, we saw the judge talking about how he was queasy, unsure of this evidence, not really sure about its reliability and stuff like that. Right? We saw that. There should have been something after that from the defense. It didn't happen, by the way. It didn't happen because the prosecution took over and they kind of forgot about it. Right? But the defense should have said something then. But if the defense didn't say something then, they should have said something now. The judge is handing it to you. They are handing it to you. This is not the first time we've seen it. The judge is giving you the words you need. All you need to do as a lawyer is just repeat back the exact same thing the judge told you in slightly different verbiage. They're handing it to you. They're giving it to you. The judge just told you that they said that there will be a day of reckoning. They just told you they're unsure about this video. They just told you they're unsure about this video quality and all the rest of it. Okay? They just told you all these things. Here's what you do. Here's what you do. All right? If you're the defense lawyer. What you do, as soon as the judge stops speaking, what you do is you get up on your feet, or not in this courthouse, I guess, because we're doing seating objections. But as soon as they stop speaking, you speak first. Don't let the prosecution speak first. You speak first, because they're hitting it. They're giving it to you. And if the prosecution speaks first, you're going to lose the opportunity. So you need to get in first. And here's what you need to say. You ready? Your Honor, We couldn't agree more with what you just said. You have said that there would be a day of reckoning, and that day of reckoning is here. As Your Honor said earlier, not an hour and 20 minutes ago, you were feeling queasy about this evidence, and Your Honor just said it again just now about how they felt queasy and unsure about this evidence, about the quality of this evidence, about the expert who testified about this evidence, about what the evidence can reliably show, its truth, its accuracy, its fair representation of the events. And Your Honor had said that they were feeling queasy about this exact same evidence even earlier when we first objected to this evidence being brought in. Now, Your Honor, as we said in our motion for dismissal with prejudice, we think that this is just part of a pattern of conduct of the prosecution that shows that this case should and must be dismissed with prejudice. Maybe in isolation, it's not enough. But on top of the prosecution, not once, but twice, even after Your Honor specifically warned them about the Fifth Amendment violation, the prosecution brought up our defendant's failure to testify in blatant disregard, as Your Honor himself said, of his rights. As Your Honor yourself said, you were astonished by the violation as much as we were. We couldn't believe it either. The prosecution has been engaging in this kind of conduct throughout this entire trial. Insert one or two more examples in this speech that I don't have right now, because you would have, you're the guy and you know this all cold, or you should. So insert one or two or three additional examples at this point as needed. And then, Your Honor, this latest thing, the last thing that's happened in this sequence is this video, which mysteriously, the full quality video only showed up Friday after the case had been submitted. This shows a ship-shoddy, ramshot case through and through. The prosecution has engaged in bad faith, as Your Honor themselves said. Your Honor yourself said, when they said good faith, you said, I don't believe them. Your Honor has already concluded it's bad faith. And this is just one more nail in that coffin to prove the bad faith. There is no remedy other. There is nothing else that can be done to fix this problem except dismissal with prejudice. Your Honor should have the courage and conviction to do exactly what you said to do. The day of reckoning is upon us. Now's the time, and we ask for that dismissal with prejudice. Something like that. Some version of that. Right? It doesn't have to be exactly that. There wasn't anything magic about what I said, except I'm using his words. Right? I'm using the key words that he used. Day of reckoning, queasy, shoddy evidence, unsure expert. You said queasy earlier. You said you were astonished. Right? Nothing magic about what I did. Nothing up my sleeve. I just took the key words from the judge, the key phrases I needed. I knew which key phrases I needed to get into this speech. Right? I need to get these key phrases in here somewhere. And then I just wrote a speech off the top of my head, putting those key phrases in there. It's not hard. It's not hard. He's giving it to you. He's giving it to you. Just repeat back literally what he told you. He's giving you the answer. Just tell him the answer back again. He's giving it to you. And then the prosecution's going to get up and bitch. And then all you have to do, when the prosecution gets up and bitch, you know what you do then? You know what you do after the prosecution gets up and bitch? You use his words again. You rewrite a speech in your head on the fly using the key words. So basically, you just give a different version in different order with different sentences of the speech you gave the first time, but using the key words. It doesn't have to be the same. In fact, it shouldn't be the same. Not that you'd be able to remember what you said the first time anyway. Doesn't matter. All you have to do is say the key words. Put them together in something resembling a sentence and structure so that it makes sense and is coherent. Just say it back to him again. And if the prosecution gets up and objects again, you know what you do again the third time? Just do it again. Literally the same thing. Just literally do the same thing the third time. Take your key phrases, rewrite it, put it in a different order, maybe echo some points of the prosecution if they made some mistakes along the way, right? You can echo things they just said if it helps you, because again, using their words is always helpful. So maybe the prosecution will give you something new. Maybe the judge will give you something new, right? So you can be listening and paying attention, because the prosecution might give you a key phrase or two. The judge might give you a key phrase or two as this is going on, and you just use that and you reincorporate it and you just give it back to him again. Like a mama bird regurgitating the food into the baby bird's mouth. You just give it back to him again and again. It's what Your Honor said. We couldn't agree more. Some version of that. Some version of that. And the fact that the defense can't do this is blowing my mind. And this is not the first time. It is by no means the first time I've seen this defense do this. They've done this repeatedly throughout the trial. This is not a one-off, or I wouldn't be ranting on it this hard. They've done this multiple times, where the judge has given them the answer. They gave you the answer. All you have to do is literally repeat back what the judge just said to you in different words, in a different order. Just use the key phrases, the key words, and you're there. It's not hard. You should be able to do this. And the defense just repeatedly fails over and over to do this. It is unfreaking believable. Unfreaking believable how bad the defense is. Not only can they not write their own things in a story, although the closing was better, at least for using the witnesses in a chronological order, which isn't the best way to do it, but it was better than anything the defense had ever done before. So the chronological order isn't probably the best way to do it, but at least it was something that organized their thoughts. So not the best option, but it was better than the nothing they had in opening. So not only can they not write their own stuff, they can't even steal the stuff from the opposite side or the judge. And it's obvious. It's obvious. It's so obvious. Why? Why can't you do this? It's not hard. Just pay attention. They're giving you the answer. Just feed it back to the judge. Jesus Lord. All right, now I'm going to answer some questions now that I've been ranting and saying the same thing multiple times. Let's take a look at the Super Chats. Super Chats are on the bot. Ooh, nice. Let's take a look at the bot. Someone asked, will Krause give sworn testimony over the drone film? Not at this point, I don't think, no. The denialist says, I ain't no lawyer, but I would have pushed the judge to make a ruling on the mistrial, to the point of being dragged up to court for him saying yes or no. Yeah, how about, the prosecution keeps winning by just keeps talking until they win. Why can't you keep talking till you win? Why can't you keep talking till you win? I mean, they keep talking till they win. Why can't you keep talking till you win? Just steal what they're doing. I mean, what they're doing is obviously working, right? So again, this is just paying attention. Maybe you don't know anything about this judge going in, which could be true even for an experienced person. They don't know anything about this particular judge. Your opponent has a strategy. The strategy just keeps working. Just steal their strategy, right? If you didn't have a strategy of your own before this, great, you do now. You've seen them use this strategy a couple times to success. All you have to do is steal. It's working. Just steal it. Just yoink. That's mine now. I'm going to do the same exact thing. I'm just going to keep talking and keep talking till I win. Why not? Do that. Ghost of Recon gets $4.99. If Kyle's acquitted, could he sue Richards for incompetence? Yes. Yes, he could. For ineffective assistance of counsel, to put it more properly, but yes. Or malpractice, I guess, would be the right thing if he's acquitted. So it'd be malpractice. So yes, he can sue the lawyer for malpractice. I'd be half tempted to represent him on that one. Water Jabber says, Kyle needs to fire these clowns and get a better team if this goes to trial again. They're embarrassingly bad. I tell you the truth, my friend. I tell you the truth. I've seen mock trial and moot court teams that are way better than this. Even for the prosecution, to be quite honest. J. Rock Pierce says, I hate to say it, but do you think the jury isn't reaching a verdict on purpose to cause a hung jury? Then it's not their problem anymore. Don't know. Interesting idea. The TRH51. Thank you for your service as devil's advocate on Rakita's stream. You know, just try to give an honest opinion either way. So I appreciate your kind words. Larson says, can the judge still rule in the motion with prejudice? Yes, sure, the judge can still rule in the motion with prejudice, but why give the judge the other option from your own mouth? Because a dismissal without prejudice is far less controversial than a dismissal with prejudice. One means it can come back. One means it can't. One means we get to go to trial number 2. One means there is no trial to number 2. This is the end, my friend. The lonely end. The end. But why give it to him from your own mouth? Why make the motion without prejudice? Why give him from your own mouth this easier option? It's not like the judge didn't have it already, but why do you have to feed it to him? Bad defense team. Nero Zed says, I guess the judge wants the jury to do the work, follow the process. This is a hot potato. I don't think anyone wants to hold the endpoint. I'm not saying that the defense would have necessarily won, but they wouldn't be ineffective. And incidentally, they might have won, not because they did it today or they did it twice today. That might not be enough. It might be enough, though, if they had been doing it throughout the trial, right? It's the straw that breaks the camel's back sometimes. So maybe it isn't enough. Maybe it isn't enough to do this perfectly at 5:03:45. Maybe it isn't enough to do this perfectly at 3:34:40. Maybe it's not enough. But you know what would help a lot? If you did it perfectly, if not even perfectly, if you did it good. If you did it good the day before, and the day before that, 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 right? Maybe it's a straw that breaks the camel's back thing. Maybe this will be the time they say yes. Because, I'm not convinced yet. I'm not convinced yet. Oh, I'm convinced. That seems to be the way the judge does these things anyway. So the judge might have said no. It would have helped a lot if the defense hadn't sucked the day before and the day before that and so forth and so on. Joanne Smith says, this judge is weak. All bark, no bite. Hoping I'm pleasantly surprised. It would help a lot if the defense was just doing what the prosecution's doing. The prosecution's doing it and it's working for them. Why not just do the same thing? I mean, if you don't have a better idea, which you clearly don't, right? I mean, your strategy is obviously not working. Why not just steal their strategy? It's in open display. Just steal it. Yoink, that's mine now. Maybe it'll work for me too. Why not give it a go? What's the worst that can happen? Pin Throttle says, question, why can't the jury be told about the prosecution lying and fumbling with evidence? Proof they're lying and tampering with evidence. They can only be told what is, on the record, and no. Mandrake says, I don't care what anyone says. This isn't strategy. They're inept. Unacceptable. Yeah, I've tried long and hard with my best ability to look for the strategy. Like, oh, this is all some sort of super masters class of Go, of 8-dimensional Go that us mere mortals are only on rare occasion the privilege to garner the slimmest glimmer of. I've desperately tried to look for something that represents sanity, and I can't find it. It doesn't make any sense. Why do they keep failing to object to blatantly objectionable things throughout the trial? Amazing. Amazing. Anthony says, can an amicus brief be submitted to this court? Yes, I suppose it could, but I just don't know what good it would do at this point, especially when the defense... I mean, what's an amicus supposed to do at this point? An amicus is really good to discuss a novel question of law, right? So an amicus would be good if this court was struggling with a novel question of law and providing an opinion on that. But I can't just offer an amicus because the defense sucks ass. Rhonda says, 4989, I think the other attorney's better than Richards. He is. He should jump up and speaking more. Seems like he's afraid of Richards. I don't know that he's afraid of Richards. He just respects his seat as second chair, and he's being demure, which is a perfectly appropriate role for a second chair. He's kind of doing what a second chair does. You know, he's letting lead counsel be lead counsel. I think that's a mistake in this instance who lead counsel is, but yeah. Lead encoder 924 says the jury played some of the videos in the jury room. So doesn't it have come into the courtroom only for the drone footage, place special emphasis on the evidence? I don't know. I don't know. The jury wanted a larger TV. I don't know if it places any special emphasis on it. 999 from Jeremy Moore. I remember prosecution saying they contacted DOJ and jury overviewing evidence would be a reversible error. Why the change of heart today? What have I missed? Thank you. Yes, overviewing evidence. So there is case law, and this appears to be the law in Wisconsin, because not all states are the same. But this appears to be correct, that if a jury overly focuses on a particular piece of evidence, then it can be a problem. Now, they talked about this case in the hearing a lot, because they talked about the Wisconsin-specific case, which obviously I don't know. But it sounds like the prosecution's saying, and without reading the case, I have no reason to contradict them other than the fact that I think that they're liars, but, you know, I don't know that they're lying about this, so I guess I'll take their word for it. But they say, I think it's Anders, or Anderson is the name of this case. Anyways, they say that the case only stands for the proposition that undue emphasis on video testimony only applies to witness testimony. It only applies to witness testimony. It doesn't apply to other video evidence. So that was the debate. And the judge seems to have come to the conclusion that the case doesn't speak to non-witness evidence. So that seems to be the reason as far as I can tell. 449, Marty McFly says, does verbalizing now they want a mistrial without prejudice now trump the previous written request? No, it doesn't strictly speaking trump it. It doesn't strictly speaking trump it, but now you've given him two options and one of them sucks. Why do you want to give him the option that sucks from your own mouth? It doesn't exactly undo it. It's just like, why, you know, you could have $1 billion or you could have 10. It's like, you know, why, you know, yeah. Kyle Cowden says, do you have an opinion on Prosbach's late tweet, the jury's ready to quit, but the judge is holding back now? The judge is holding back? No, that doesn't make any sense. Why would the judge hold back? How would that even happen? That doesn't even really 100% make sense, to be quite honest. What is he saying? Let me see if I can find this tweet, because that doesn't really make sense. Let's see. Let me see if I can find this tweet. I can't find this tweet. I see his tweet about Kyle Rittenhouse's prosecutors lie to criminalize self-defense from 3 hours ago. Okay. Oh, here's what he said. This is what he said. He said this 10 hours ago. Judge was hoping for a quick acquittal, but holdouts didn't want the media backlash. Now the holdouts want an acquittal, but the judge doesn't want the media backlash. That doesn't make any sense. Yeah, with all due respect to Jack here, that doesn't make any sense. If the jury has a verdict, they would just submit a written declaration to the judge, right? In the same way they've sent these 5 questions. So if the jury has a verdict, they just send, a piece of paper that says we have a verdict, and it goes to the judge and he reads it in open court. So that doesn't even make sense. It doesn't make sense that they're ready to acquit and the judge is holding them back. That doesn't make any sense. I don't get it. $4.99 from Still Sleeping. If he's found guilty, then the judge will call it a mistrial. He's just waiting for the right time to call. It could be. It could be. Let me take a look at the bot and see what it has to offer. Let's take a look at the bot. Ooh, super chats. That's cool. That way I can see all the super chats. We might have to separate those out into some way so I can see them separately rather than putting them together with everything. But I do like what you're doing here, Matt. Thanks, Matt. Matt's one of my mods, and he also helps me on the back end, and he wrote the bot to help me catch the chats. And so now he's modified the bot to capture super chats, which is awesome. So thanks, Matt. I think maybe we'll have to find some way to put the super chats in either a different thing or put them somewhere so I can see them separately to make sure I don't lose them if I get tired. But I really appreciate it. Thanks, Matt, for all the effort. You're awesome. And thanks also to Stephanie, our head mod, for all of her hard work in helping to get other things together. For example, here's some things that are probably coming down the channel, and these are things that Stephanie has put together, so everyone can say thank you, Stephanie. We are probably going to open up a Patreon pretty soon. Because it's a method of support that's common to everyone. I've had my misgivings about Patreon as a company, but it's a method of support that a lot of people use, and so so we're looking at that as a possibility. And we're also looking at new member benefits that would come along with higher levels of support. These things that we've discussed might include such things as, is that enough qualifiers for you? Might include such things as, we're looking at doing some games together. So we would do like murder mystery games, or there's a game called I Dissent where you debate stupid questions in a format with a moderator and stuff like that. So we could have a game night where people at certain tiers would be invited to play, or things of that nature. So that's kind of some of the things we're looking at to come down the pipe. So thank you, Stephanie, for all the hard work behind the scenes and trying to see if we can put that together. She's an awesome asset, and it's very much appreciated. Let's see, where was I in terms of the bots and stuff? Danielle said it's the Keystone Cops versus the gang that can't shoot straight. Truth. Defense is also getting so much help with the background with crowdsourced research. Truth. If this goes on any longer, judge is going to have to start running back and forth playing defense and judge for Kyle to have a chance. Can we talk about the fire extinguisher? We may have a fire extinguisher tier. Yeah, that might be fun. Maybe one of the tiers on Patreon can be the fire extinguisher tier. That might be fun for a callback. QAnon shaman guy got 4 years in federal prison. For those of you who might have missed the memo. QAnon shaman guy got 4 years. So, don't try to commit riots in the Capitol and stuff. If it's dismissed with prejudice, can that be appealed? No. Are we to believe Richards is sounding incompetent? You're sounding more like Barnes every day. Well, man, I have eyes. Barnes and I have certainly disagreed deeply about things from time to time. But I don't disagree with Barnes just for the hell of it. Nor do I disagree with anyone for the hell of it. I've even before produced a video praising Legal Eagle about something. I know. It's amazing. But, I thought he really got something right, and so I made a point, or maybe it was a community post, either way. But he made a video that was really good, and I'm like, okay, yeah, that was really good. Legal, you're one for, 50, but congratulations. Right? I just try to assess everything onto its own merits. So, yeah, I'm looking right at this guy, and I'm saying to myself, this guy's a complete idiot. So, that's my independent assessment. So, Barnes and I agree, because it's dumb. Someone said, come on, man, damn well January 6th was not a riot. All right, let me say this to you, Christopher Tanase. January 6th was a riot. By any definition that you want to pick. I don't know what definition of riot you can possibly use that would apply to other incidences that you might want to designate a riot and wouldn't apply to January 6th. I mean, please provide me a definition of riot that would, for example, include the BLM Antifa stuff that we saw, but would exclude January 6th. I'm going to stick with riot. It's a riot. It was a riot. Yeah. How's that for you? The fires. Oh, the fires of fire. So if it has fires, it's a riot. But if it doesn't have fires, it's not a riot. So it's only a riot if it has fires. I don't know, man. Try again, I think. Have you seen Evans Profs on Twitter bring bag takes? He says Banger's Fifth Amendment annex were perfectly fine. No. And the drone footage isn't Brady because it's not exculpatory. No. But thank you for playing. Tommy Gunn AR says Uncivil Law, Kirk. First of all, it's K-U-R-T. Kurt. K-U-R-T. Spell it right, heathen. Tommy Gunn says, you know damn well that was a government agency that was doing all that commotion. It was not the people who set it up. It was... Wait, I gotta read this tweet full because this is just too much fun. I don't want to bother me. It was not the people who were set it up. It was not the people who were led into the building. Uh-huh. It's the government false flag. Sure. Uh-huh. Yeah. No, but no. This isn't a riot because it was all set up by the government. This is all a massive government op. Uh-huh. No, yeah. Ah, Lord. Let's try to keep things in the realm of, the plausible and not, the fanciful. Question, why the judge throw away key fact the most glaring? The kid would not only cross state lines, he was underage with a deadly AR. Cute. Nice one. Someone insulted me. Rostin, that wasn't very nice. Richards needs a notepad with the word object. Yeah, I'm just going to send that guy all the Phoenix Wright games in the mail. Just play the Phoenix Wright games and, What case do you cite for Day of Reckoning? I don't have to cite a case for Day of Reckoning. The judge said it. What do I care where it comes from? It's his words. I don't care. If dismissal is without prejudice, does that preserve Kyle's financial future? Well, he has to pay for everything and pay for it again, so no. Watching daily, you can lead a horse to water, but you can't make Richards drink. Okay, great. John said, feels like everyone involved is scared of the public and the mob outside. Yeah. Can we install a shock collar on Richards? Are you sure they're not playing 3D chess? I'm pretty sure. I'm pretty sure it's not 3D chess. Yeah, I'm pretty sure. And not only am I pretty sure, but the entire panel of lawyers on Nick's stream is also pretty sure. So I got, 10 other lawyers, 11 other lawyers, 12 other lawyers. I don't even know how many lawyers are on this panel totally. I mean, 10 at any given time, but, you know, it changes. How many total lawyers have we had go through this panel? So maybe it's 15. I've had, I don't know, 15 different lawyers all tell me the same thing. So I'm kind of inclined to believe it. Marty McFly says, I think you turned super chats off. I don't have the option. I did not turn super chats off. So maybe your credit card needs to be set up or something. I don't know. Should the judge force the jury to play Jeopardy so they'll give up? Isn't there something wrong, sort of just with the linguistic aspect of playing a game called Jeopardy during a murder trial, which Jeopardy is an issue? This is Jeopardy. Well, no, Alex, actually, this is Jeopardy, but yeah. Do you think Binger has something over the judge? Nah. The judge is more. No. I don't think this is on the judge. I really don't. I don't think this is on the judge. This is on the defense team. This is just the defense team. You know? If the defense isn't going to put up a fight, you know, a judge looks at the parties before them, right? He looks at the parties before them and he looks at the argument between the two parties. So if one of them doesn't want to play, you know, it's like a ref in a football game. What do you want me to do? They just keep scoring. You know, what do you want me to do? They're not doing anything. You know, so I don't think this is on the judge. I think this is pretty much totally on the defense team. I think it's on the defense team. Someone asked, do you think Richard's even trying? I know Kyle has the right to choose attorneys, but would the same prosecutor try the case? That's up to the prosecutor's office. So I couldn't answer that for sure either way. Graham's Bar says, are you from Kenosha because you're on fire? Fun. Can a defendant object if they have Richards as their defense attorney? Yeah. 1,300 people were watching? That's true. 1,300 people are watching. Thank you very much. I tell the truth regardless, right? I consider myself a member of the right. I consider myself a Republican, but I try to be, you know, actually apply my principles consistently. Because I think that would be a good thing. You know, I try to apply my principles consistently. I try not to special plead, which is another version of my rules for me, but not for thee, right? Special pleading is when there's a rule for me, cause. So I try to avoid that. I try to have the same rules consistently throughout. So, for example, if I'm against BLM and Antifa rioting and destroying property, which I am, then I'm against the people on January 6th who destroyed property and rioted. And I really don't give a damn one way or another, whether they're QAnon, whether they're BLM, whether they're Antifa. You know, that was my personal favorite thing where people said, oh, this is really just a BLM Antifa thing to make the right look bad. I'm like, I could give two shits either way because my principle is the bad guys go to jail. So I don't care. I don't care because, you know, I actually try to apply it consistently. I don't care if they're MAGA. I don't care if they're BLM. I don't care if they're Antifa. Here's a thought. How about, you know, we say that rioting is bad. Trespassing is bad. Destroying property is bad. How about that? How about that for an idea? That sounds like fun. Stephanie says I should get back to Rittenhouse. Okay, we could do Shaman a different day. Back to Rittenhouse, says Stephanie. Stephanie helps keep me in track. That's cool. All right, where was I? What on earth could the jury still be discussing? I mean, are they just dragging this out to help Nick's sub count? I don't know. It seems like there's one or two holdouts, which might be 3 or 4 at this point, but I don't know what they're discussing. I mean, obviously they're going through the video with a fine-tooth comb. So someone's trying to convince someone that they do or do not see something. Link said, Uncivil Law, you rock this morning. Thank you. Thank you for all the content. It's fun and informative. I saw a copy of the witness list that includes Brandon bemoan. Drone operator. Have you seen a witness list that includes him? Last column halfway down. I haven't seen him. I haven't seen a copy of the witness list. They recited every single witness when the jury was being selected, so that information's in the public. They recited it orally, but I don't know if it's on the list or not, but it wouldn't surprise me. Stephanie says they want to see you. They're begging you to wear the hat and acting thirsty. Okay, you know, if the chat wants some hat action after dark, you know, make sure your kids are asleep because there's gonna be some after dark hat action. Okay, hold on. I even do one better. I'll even do one better for the chat. You ready for this? You ready for this? I'll do one better for you guys. I'm doing this for you, the chat. I just want you to know. I'm doing this for you. Because I love you. What could he be doing, you think to themselves? I don't know. What could I be doing? So many things. So many things. Oh, Lord. Oh, yeah. Okay. Yep. Oh, yeah. Ready? You ready? Here I come. Yeah. Yeah. Polo. Polo tie. Yeah. All right. Let's read some more stuff. Bolo with a polo, baby. That's right. Bolo with a polo. Oh, yeah. All night long. All night. All night. All night long. All night. All night. Let's see. Let's do some more things. He looks like an actor, but I can't think of his name. Well, there's a couple different options, but Philip Seymour Hoffman tends to be the most common. But the guy from Tenacious D also comes up a lot. Kyle. That comes up a lot. And I've been told I look like someone from the Waltons, but that's only by really old people who watch the Waltons. Joe's Auto Electric says, with the group of very intelligent lawyers you've been streaming with, there are none of you who could step in to help this kid? We really can't. We can't solicit clients. We can't solicit specific clients like that. And he's already represented by counsel. So there's ethics problems. What is this case? Nothing really makes sense to me, and I've been watching you crazy lawyers. Is it a good thing the judge is waiting to see if the jury will give a not guilty verdict before making an objection? Yeah, probably, because if the jury comes back not guilty, it just solves him a whole bunch of problems, right? Because they do it for him, so he doesn't have to worry about things. So I can't necessarily blame him for it. It's a bit of a passive approach, but it's one that's very understandable, even from first principles. Someone asked, what's the difference between a mistrial with and without prejudice? Yeah, with and without prejudice refers to prejudgment, right? So we are prejudging the case if it's filed in the future. So if it's with prejudice, we're literally saying we're prejudging the outcome. in the future, right? That's what it means, right? So if we say with prejudice, we're saying, yeah, you can file, if you file this again, we're going to tell you what the result is. So basically it's saying you can't refile. How can the whole case hinge on a video that wasn't admitted to evidence until the middle of trial? It doesn't matter when it was admitted to evidence if it's admitted to evidence. What was the probable cause for pursuing first degree if the smoking gun was missing? Oh, I mean, yeah. Can you share your thoughts as to why the defense isn't good? I'm curious to hear. I think I've been doing that pretty thoroughly throughout the stream. They fail to object constantly. They fail to zealously advocate for their client. They fail to take obvious opportunities from the judge to just feed him back his own words and basically get the judge to do what they already indicated they want to do. So those would be some of the reasons. If a jury finds him not guilty of murder but guilty of a lesser charge, the judge rules for a mistrial without prejudice. Would they only be able to retry on the lesser charges? No, because if it's truly a mistrial, right? If it's an actual mistrial, then the judgment isn't entered, right? So if it's a mistrial without prejudice, then we just do a do-over. No guitar? I have a guitar, but I don't know how to play it. But I do have a guitar and I could hold it in my hands if that would help. I keep trying to learn. It's just, it's hard. Do not pick up the guitar. All the no, says Stephanie. I don't know, guys. Should we pick up the guitar? Stephanie usually tries to keep me. She usually tries to keep me protected, though. She's the best. She says all the no in all caps. She's great. Watching you daily says do it. I'd remind you, watching you daily, that Stephanie has bigger permissions than you. She can mod you. Watching you daily, she's super mod. She has permissions above yours. So you might want to be nice. Let's see. I'm not sure where I left the super chats, so let me see. $4.99 from Still Sleeping. If he's found guilty, the judge will just call it a mistrial. He's waiting for the right time to call it if he's not acquitted. Could be. $1.99 from Kyle. Kyle said it thought it was weird too. 50-something from No Black Thunder. The abuse by the state is crazy. Even my leftist friend is shocked. And for 100% agrees with me, Kyle's innocent. Just shocking. LG says, why is no one talking about how the defense submitted an exhibit that, as Kyle Circuit said, could be Rittenhouse pointing a gun, probably at Zeminski's? We've talked about it. We've talked about it definitely on the stream, that we've made note of it, the fact that the defense themselves, which just goes to show how idiot they are, the defense themselves submitted a video that has Kyle circled that says could be Rittenhouse, probably pointing a gun at the Zeminskis. Great, that's great one, defense team. Just super wonderful work there. $4.99 from Rhonda Ernst. I very much like your honesty. Balls and strikes is what I want to hear. €5 from Death. Widespread destruction of property and arson are part of a riot. Was that on January 6th? Again, you're really trying to contend that without arson, it's not a riot? I don't know, man. That seems like a strange definition to me. The denialist says even if it was a government op, they were dumb enough to commit a crime. True that. Matthew V says $4.99. Death says $5. I think Richards is very tiring. No, nothing more to do here. It really feels like the judge is resisting making a decision as a show of how the system works. Yeah. Marty McFly says, if there's a mistrial without prejudice, does Kyle stay in jail? He's not been in jail this entire time. He's been out on bond. How long does the state have to retry the case? I don't know those specific rules in Wisconsin. Malek Gaming and Talking says, hey, those are my shorts. Go Tigers, baby. Neo Zed says, inner city of children of promise, but without the necessary means for higher education. Okay. Annoy 14107 gave me $10 and says, as the jury deliberations have continued, what type of conversations are defense lawyers having with Kyle? I have no idea. Preparing him for the worst case scenario, by the way, great stream. I don't know what they're talking about at this point. Depress O Coffee says, how common is a jury to render a decision guilty only for the judge to rule otherwise and say there's a mistrial? It is hen's teeth rare. It's exceptionally rare. But it does happen. $2 says, if hung jury, can the judge decide not to be retried? Not because of the hung jury, no. But he can decide not to be retried for other reasons. $4.99 from Matthew says, what do you think will be the outcome? I don't know, man. With 3 days in at this point, your guess is as good as mine. I don't know what's going on. It's all blush. Oh, give me a home where the buffalo roam, where the deer and the antelope play, where seldom is heard a discouraging word, and the skies are not cloudy all day. Stephanie says no, for the love of God. Stephanie, my singing is fantastic and the people love it. They love my singing, Stephanie. It's what the plants crave. Fun times. Washington Daily says, can we have a Rorschach challenge? I think we're halfway there at this point. Tucker says jurors are stalling in fear of burning, looting, and destroying. That does seem to be a thing. Yeah, the fact that a dictionary uses the capital as an example in their definition is not exactly super encouraging, because the way dictionaries change their definitions, it's just like, that's the official tie of Arizona. Excellent. Well, I liked it. Stephanie says you didn't have that much whiskey. I'm just in a good mood, Stephanie, because I got to be with you tonight. So I don't need whiskey. Cave Cameron says, last night I asked what's the best in life. Tonight I know it is to be bolo tie with the polo. Bolo with the polo, baby. Bolo with the polo. Would you accept advice in this trial like this if other lawyers were texting you? Not unless I knew them super duper well, and probably not even then. Any advice or books you suggest for improving public speaking? Toastmasters is a fantastic place to go to learn to do public speaking. It's a great organization. It's not expensive at all, and you can learn public speaking. Toastmasters is definitely the place to start. Would you have advised Kyle to accept lesser charges? No. Oh, to accept them, or should he have just gone for the main ones? Good question. I don't know. My gut instinct is to not accept the lesser includeds, but that's a gut instinct. I definitely want to mull that one over. Ooh, I should get a harmonica. Ooh, harmonica life. That could be good. Get a harmonica, start taking some harmonica lessons. I could do some harmonica-based serenades. Yes, I'm loving it. That can also be a patron benefit. If you sign up for the right patron tier, you get to listen to me play harmonica. Yeah. Paul says, don't give up your day job. Have I talked about the people spotting handbrake on Lunchbox laptop? I didn't talk about it, but it was noted during the stream. Have you seen the mysterious pile of bricks they're showing up in Kenosha? I've not seen that, but it wouldn't surprise me. All right, so those are all the questions from the bot. Those are all the questions from the bot. So I'm going to end the stream. Roughly how long do you think a jury will deliberate? Well, I thought a day and a half. So I'm already over my prediction. So I thought a day and a half was the right number, but I'm over. So I don't know. I don't know how much more there is for the jury to really do. I mean, they've already watched the videos, so how much more is there really for them to do? So I wouldn't really be surprised if it's tomorrow. But then again, I thought it would be today, and I thought it would be yesterday, so I got nothing. When will I get a deer mounted on the wall behind you? I don't know. Thank you, I'm so tired. Thank you to the 1,000 of you who are currently watching. I really do appreciate it. And thank you for the super chat revenue. It was really appreciated. Death says, I meant widespread destruction of property or arson. What is the definition of rioting? Serious question. You mean legally or just like in terms of what I would say colloquially? I mean, for rioting, for a colloquial definition, I'd say it's a mass of people engaging in disorder. That'd be like my position of a riot, basically. And probably also maybe I'd consider like one of the following things, like, you know, breaking windows, throwing things through windows, destroying property maybe. Yeah, a mass of people engaged in disorderly conduct that includes destruction of property. That's a pretty good definition of riot. Is it against policy in most DEA's offices to email evidence from Gmail? Not to my knowledge. What happens if Kyle's found guilty, even if the evidence points to self-defense? Depends on what the judge wants to do. Is a riot the same as civil disobedience? Well, that's interesting. I haven't really thought about it, whether or not a riot is the same as civil disobedience. I guess I would use them interchangeably. So unless I think about it more and change my mind, I'm going to go with yes for the moment, but that's tentative. How many people are required? A group. How many people are required? I don't know. It's the old question of how. This is an old question in math and computer science. But it's how many, and it's probably beyond other things. It's like how many grains of sand, how many grains of salt is in a heap of salt, right? So if a recipe calls for a heap of salt, how much is a heap of salt, right? And so one of the ways you can say that, one of the ways you can ask it more precisely, is how many grains of salt are in a heap of salt. So someone might say, it's 100 grains of salt is a heap of salt. And so the next logical question is, okay, so you're saying that 99 grains isn't a heap, which of course is ridiculous, right? And then it's like, so you're saying 98, so you're saying 97, and then basically you realize that there's no workable definition of heap. It's an amount that doesn't have a specific quantifiable number. So in the same way, I'd say the group of people is not specifically quantifiable in the same way. But I'm going to end the stream. If you haven't subscribed already, please remember to subscribe. If you are... Wow. Comp, that is just way rude. That is way rude, Comp. If you're enjoying this stream, please remember to subscribe. If you are not already subscribed, subscribe. If you haven't hit the like button, do that. And for 99 cents, you too can become a member of the channel. It's true. You'll get a cool little icon by your name, and you will get access to member benefits, and I will like you more. And also, you can look down on other people that don't have the icon. So that's all for tonight. I hope all is well. Cheers and goodbye.